Hi, this is Professor McLaughlin with a Legal Research and Writing LGL 205 lecture on Chapter 12, Basic Legal Writing Skills. So for many of you, this will just be a review. What I'd like to do is go through the slides, but I'll also emphasize some of the most frequent things I see students do and things I do myself, and things that frequently come up in law documents. Why don't I mention them up front, and then we can highlight them as we go through the documents. The lectures and the slides. Really two main things. Well, three main things. One is the tone. So is it a persuasive or predictive tone? So I've had to kind of learn to use this word that your publishers use, predictive or neutral tone. Predictive meaning, is this a document written to predict how a court is going to decide something? But that tone is neutral. Not arguing for a particular decision. It explains how things are. It explains in a very neutral manner how courts have previously decided. And then if it goes on to be predictive, it then predicts what might be the outcome of a certain court decision based on how courts have decided in the past. But essentially tone also has to do with, are you writing to a client? We're going to do legal correspondence at the very end. And what should the tone of that be? And tone of email. And for that matter, just as a side note, the tone of voicemails that you leave. So always being aware in general of the tone of your communication. I know it kind of has other meanings, but it really is across all communications. But for written and legal writing, in particular for written documents, they're going to have a particular tone. It's going to be neutral, or you're trying to predict what the court's going to do, or it's going to be persuasive and argumentative. And then another big one is tense. So part of your assignment this week will be doing some self-tests that will just have you writing and rewriting in Blackboard sentences, trying to get the tense correct. So every sentence is going to be in present tense, future tense, or, sorry, I need to move this, future tense, or potentially, potentially, sorry, present, past, or future. So, and you want it to be consistent throughout. So you want to have a consistent tone to your sentences, a consistent tone to your document. Now, this becomes tricky when you talk about what the court said, what happened in your case, and what's going to happen when you go to trial. So you just need to be consistent and always editing and double checking. When you talk about what the court said, it's past tense or it's present. The court said. Now that's the court says. It's going to be past tense. It's going to be past tense if you're talking about what happened in your case. It's going to be future tense if you talk about what you predict is going to happen. And then present tense would be, are you talking about the current discovery process? Where are you in litigation? Is it a bankruptcy? Have you completed these forms? So depending on what the writing is, making sure the tense is correct. And that goes for client letters and emails as well. And then passive voice, we'll talk about that we'll talk about that within the chapter, because that's a big one in legal writing in general, and always making it active. And this is part of the chapter, but making sure you're not being passive voice and you're using active voice. All right, so let's get into your slides for the chapter here. So for any writing, you don't probably need to do this for an email. It depends on how long the email is. What if it's a fairly long email, an informative email? You're sending it to a large group of people, explaining, maybe there's a meet and confer. You want you have multiple parties coming to a discussion conference with the lawyer, and you want them to bring documents, and you want them to understand what's going to be discussed. I mean, you could have very long emails, but in general, outlining before you write is so important. And in law, this looks very much like a IRAC, the issue, rule, application, and conclusion. In law, IRAC's just useful, but it's not everything. Some documents are going to have an introduction. Some documents are going to have a statement of fact. This looks very much like the predictive memo, which we're going to talk about in the next chapter. It's got an introduction, statement of facts, and discussion of the rule of law, identification of the rule of law, and then an application or analysis section where you're applying those rules, the law, to the facts of your particular case. So IRAC, and you've done that, and case briefing helps you identify what analysis looks like. Well, I'm not going to have you write a predictive memo. I've done that in previous semesters. Don't think it's useful. Students really struggle with the analysis portion. We'll do some activities in the final weeks that'll get you practicing the analytical. It's really important just to get the statement of facts, what are relevant facts, and some of the work that we've done this semester, identifying issues and rule of law down. Analysis will come with time. Analysis comes with experience, and it's difficult. We all struggle with it. It's difficult in legal writing. Better to have you reading lots of cases and seeing how a judge analyzes things. Okay, some basic considerations, and following along in your textbook. I'm on page 309, and this is, what slide is this? Slide 3. So, topic sentences, identifying the thesis, for each paragraph, it's going to be a dominant point that you're trying to make, and understanding and outlining is very important for that. So if you're outlining, you are able to really have a well-constructed paragraph because it will have a topic sentence, which is the thesis, what you're talking about. You want to use active voice to what you're talking about, and the thesis of your document as well. There's going to be an overarching thesis of your document, and also a thesis for each paragraph, a subtopic. And in law, sometimes it's really obvious what that's going to be. Your thesis could be discussing a particular case, and then the next thesis for the paragraph is how does that case apply to the facts of your client's situation, that kind of thing. Okay, now active voice, so important. Active voice is simply using subject, verb, object. So if you look on page 309, there's a lot online. Let me see if, without being too messy, if this will work. I don't know if I can adjust this. Maybe at the end I'll show you a couple of websites that are really good. But I'm going to encourage you to look up using active voice online, and you'll find the Purdue website for grammar. You're going to find a lot of grammar resources online. Active voice is when you start with the actor, you mention the action, and you move on to the object of the action. So if you look at the examples on page 309, active voice, and for those of you who aren't looking at the book, let me just read a couple sentences. Passive voice is this: it was not long before her actions made her sorry that she had done what she had. Rewriting that sentence into active voice would be, she soon regretted her actions. So object she, moved to the action, regretted, and moved to the object, her action. So spend some time with that. I didn't put a self-quiz on active voice for you, but it's super important in your writing, and I'll point it out as we move on to the final assignments in this class. Avoiding noise words. So it's unnecessary to be flowery in law. It's much better to be dry and simple. So noise words are going to be words that don't add any meaning to the sentence, and maybe give a sense of formality, but don't contribute to the reader's understanding. So always approach your writing very pragmatically, very simplistically. You don't want to sound sophisticated in your legal writing. And yeah, sometimes judges get all flowery and la-di-da. We don't care about that. We only care about communicating clearly to the attorney, to your fellow workers in email and in any written form by eliminating nonsense words. So now noise words noise words should be distinguished from words you believe you need to use to fully express yourself. By noise words, I mean cut out superfluous words, extra words. And finally, use front-loaded sentences. So in law, we do this all the time. You want the most important point written first. You want that to be the first point in your email. You want that to be the first half of your sentence. We do it because we know people skim our writing, but we do it because that's what we do. And the most important point is first, and we front load the sentence with important information. And also, I mean, it's a follow-on. When you look on page 310, start the sentence with the actor, move to the action, and then move to the object. That's important as well. But you also want to put your really, really important concepts, arguments first at the beginning of the document, the beginning of the, don't wait for the punchline. Put the punchline first, and so people don't have to wait and wade through all your writing. So keeping legal writing simple. You may think lawyers don't do this. It's encouraged more and more to do this, and maybe some of the cases you're reading don't do this, and that's bad legal writing. So using short sentences, avoiding unnecessary words, and using specific and concrete terms. So, predictive writing. So your authors like to describe the legal memo as predictive writing. It's writing that is looking at the cases around, analyzing the case that's before the lawyer, and then coming up with a prediction of what might be the legal outcome. It's very neutral. It does use point headings. I'll put some, you have great examples of legal memos in chapter 13, which is the next chapter. And use of IRAC is encouraged. So identifying the issue first, rule, analysis, and conclusion. You can use crack, or you could use ICRAC, the issue, conclusion, or there's so many combinations. Use IRAC as a loose suggested structure, but don't let it limit you. If in your writing you feel something should go before something else, do that, or something. So if you look here on the slide, crack, the conclusion is stated twice. And if you feel that really needs to be true for a particular document, do that as well. Explore that. So writing the conclusion first, then having the rule, having analysis in there, and all of these are going to be set apart by headings, and you'll see that in chapter 13. Persuasive writing are all the documents that go to the court. Your petition, your claim, your response. A demand letter is persuasive. A memo of points and authorities. If you have to brief a legal issue, the trial brief is persuasive. Appellate briefs to the appellate court are trying to persuade the reader to the writer's point of view. Okay, so let's get into what a thesis paragraph looks like. On page 318 of your book, the thesis paragraph. And this is where I think the authors, I like this book, frankly. This is where the authors do a very good job of giving you examples based on cases that you've read over and over. So I like that. I really think that the pedagogy is very solid in this book. Anyway, so you're going to state the legal issue first, explain the rules of law. Hey, this sounds like IRAC. You're going to state the legal conclusion and, if appropriate, the relief requested from the court. That's your thesis paragraph, and there's a couple of good examples in your book. Now, really, really important is the editing process. So editing your documents, rereading. I suck at this too, so I'll just tell you. I usually send my articles out for someone else to read and give me feedback. And you can do that too. You can exchange your writing with someone else, ask them to give you comments. I do print out everything I write, even before I send it to the other person, so I can see obvious, not just formatting, but obvious flow problems. I scan it. If I'm too tired of reading it, I send it out. Rereading your paragraphs for a topic and transition sentence. Transition sentences are super important, making sure the reader is following your change of the sections of your document, moving smoothly from one section to another with a transition. And looking for revisions, looking for sections that are presenting an argument and making sure that section begins with the thesis paragraph. Rereading to make sure facts or law that support your position are included in there. And not having a passive voice, making sure everything's clean and active. Going back, so sometimes when we write as we think, it's helpful to reread the introduction to make sure it is truly putting your most important point first, but also says what you mean. So sometimes when we write our introduction or we're trying to kind of get into a piece of writing, how we write is not always how we initially write is not always the clearest steps into the water. Rather, it's really important to go back and make sure that just the introduction is so important. Introductions are that you can win or lose the reader based on the introduction. And so you want to make sure that and the introduction can provide you with the structure for the document. The introduction can encapsulate what you're trying to present in a piece of writing. Even for your memos and some of the other writing you're going to do, your case briefs for your other courses, a clear introduction is going to be, it's just going to ease the way for the reader, and it might ease the way for you in how you want to structure your document. And then rereading the conclusion. Does it really clearly state what you were trying to say in that particular paper. All right, so sticking with trying to spend a little bit more time on citation in the Bluebook. So the ellipsis. Ellipsis is that ... and this is on page 328. The ellipsis is a ... and is frequently used in legal writing. And it is used for quotes where you are skipping part of the quote, and it lets the reader know that you've included only pieces of that sentence and not, or that paragraph, and not the entire sentence or paragraph. Moving on, kind of if you're reading along on page 328, there is another rule that says never use an ellipsis to begin a quotation. Instead, you're going to use the brackets as you see displayed on page 328. The middle of that box, the statute imposes special prohibitions on those speakers. The brackets around the T indicate to the reader that that's not the beginning of that sentence in its original form, but instead it is a partial quotation. And that's kind of it. So that's chapter 12, and grammar is something we continue to work on all our years of writing, and I will see you for chapter 13.